We're now live streaming on YouTube. This is Judge Dulce Madrigal. I'm hearing cases in Guadalupe County today.
All right, we're kicking off with a child support modification hearing. But here's the thing. These cases can get messy, fast. The judge is already laying down the rules, making it clear this isn't a full-blown district court. Trial. Keep an ear out. Court procedures can make or break a case.
Let me start with the non-custodial parent, Marco Adam Acevedo. Sir, go ahead and announce yourself with your full legal name.
My name is Marco Adam Acevedo.
Thank you. And you're in your lawyer's office on the same device. Mr. Carl Mangine, sir, if you would go ahead and make an announcement.
Yes, Your Honor. Carl Mangine. I'm representing Marco Acevedo on this matter.
Thank you. Now, the custodial parent is Desiree Nicole Chester. Ma'am, go ahead and unmute. And if you don't have any background noise, you can stay unmuted.
Desiree Chester?
Thank you. Desiree Nicole Chester, middle name?
Yes, ma'am. Desiree Nicole Chester.
Thank you. Now I need to swear both the parties in. Mr. Acevedo, Ms. Chester, if you'd raise your right hands for me. Do each of you swear to tell the truth, the whole truth, and nothing but the truth? Starting with you, sir.
I do.
And ma'am?
I do.
Judge Dandrikos for the Attorney General. We're here on a modification.
Okay, I've sworn you in. Now I need to tell you a few things before we get started. I may have said it before, but I'll say it again to remind you. I'm not a district court judge with a court reporter. I'm an associate judge. I've been appointed to hear child support cases filed by the Attorney General's Office Child Support Unit. They give us a digital recorder, not a court reporter, so be mindful of that. No, make sure all your answers are verbal, loud enough for the recorder to pick up and the court to hear. No shaking your head or nodding. That does not record. No ahas or ahs. I need formal yeses and nos. So with all that, let me start with Ms. Coates. Go ahead and start your opening statement since you're the ones that filed this action, followed by Mr. Mangine's opening statement.
Yes, Your Honor. So we believe at this time, when we originally filed this, that there was a change, Your Honor. However, based on Ms. Chester's, we believe testimony is going to state that they're still doing their 1 week on and 1 week off. And however, she asked us to file because at the time of the filing, they were no longer doing that. But now it is my understanding, and again, we'll get this out in testimony, that they are still doing 1 week on and 1 week off. And this was put into their final divorce decree, which they're trying to modify, the final divorce decree. In the final divorce decree, there is no child support set based on this fact that they're doing 1 week on and 1 week off.
So here's the key legal takeaway. Modifying child support isn't automatic. Texas law requires either a significant change in circumstances or a 3-year gap with at least a 10% difference in support calculations. The mom filed based on a change, but it sounds like things went back to normal. That could be a problem for her argument.
That is considered deviation. And based on the testimony that if they are still doing 1 week on and 1 week off, then the rule, the Texas Family Code of the 3 years with a 10% no longer applies, but in fact that there has to be a substantial and material change. And aside from the possibly they're no longer continuing it or they are, there's no other changes that I'm aware of, this office is aware of, that would qualify as a substantial and material change at this time.
And did I understand they're modifying the divorce decree, or did I?
Yes, they're trying to, we're trying to modify the divorce decree to set child support. Based on at the time of the filing, we were told that they weren't following the possession schedule anymore, so yeah.
So I followed all that. I was just not sure if they had an independent action over there with the district courts, but that's not what you're saying. This is the action they have here through your agency, Ms. Coates.
Yes, we're trying to modify the divorce decree that was signed January 8, 2021.
Okay, I get it. There's nothing else pending. Thank you. Mr. Mangine, any opening statements, sir?
Yes, Your Honor. Just a short one. My client's contention is the same as the state's. The child custody has not changed. It may have for a time under circumstances, but right now it's still 1 week on, 1 week off. Mr. Acevedo is, and it's one of the reasons I had the monthly expense statement, because he, in the 3 years since the divorce, he has a well-established budget in taking care of the home for the children as well as the children.
Oh, here's where things get interesting. The dad's lawyer is making a strategic play, emphasizing that his client's financial situation hasn't changed. This is important because if the court agrees, the request for child support could get denied outright. Also, listen to how he frames the expenses. He's setting up a defense before the mom, even gets deep into her side.
And so right now, what he has left over is not very much money. So we contend that since nothing's changed materially as to the custody of the children in that situation, that the child support would be inappropriate at this time.
Okay, I'll hear details, I'm sure, through the testimony. And also, Ms. Chester, since you're here without a lawyer, you still have the capacity of representing yourself. What I do, though, is instead of letting you make an opening statement right now to tell me what you think should happen, then you're still gonna, under oath, tell me as testimony what you think should happen instead of doing it twice. I just go straight to the chase, let the AG call you, and so you can tell me one time under oath what you want. Okay, Ms. Coates, I'll let you start calling witnesses.
Miss Chester?
Yes, ma'am.
Okay. How many children do you have with Mr.
We have 3.
And are they all under the age of 18?
Correct.
Now, it looks like we filed this back in September 29, 2023. You had asked for our help, is that correct?
It had actually been filed previously before that. I don't know. I know it was like 2 years prior, but I had never heard anything from it. So that's when I had called back and they had showed me how to properly file. But yes, correct.
Okay. So my understanding is that you are asking for child support because there was a change in the visitation.
So the thing that was listed on there was, I know we were getting more time with the kids at the time. It was only like a day, but then we would go back and forth the same. The reason for the request for the modification was the fact that I did get let go from my job because of the school schedule, for the kids. So being that I do live so far away from the kids to school, they had to let me go because I was doing drop off and pick up and just waiting there in the line. So I did have to be fired from my job. So that was the reason why I had asked for some assistance.
Okay. So the visits had never changed. So you were still doing 1 week on and 1 week off.
So we were getting the kids, me and my husband were getting the kids an extra day. And so they would add up, but I couldn't tell you how many days they added up. And then it went back to being the same.
Why were you getting the kids an extra day?
There was just like stuff that was going on. I believe there was like sickness. I don't know. I don't remember which individual it was, but it was like a few days here and there.
So were these extra days?
Modification was not for the visitations. It was more because of the financial, because I did lose my job.
Okay, so the extra days weren't because Mr. Acevedo didn't want to see his children or take care of his children. It was just something came up.
Yeah, there were things that came up.
Okay.
And here's the pivot. Mom just admitted she's asking for child support because she lost her job, not because dad isn't paying his fair share. Legally, that's a big distinction. The court isn't here to compensate her life choices. It's about the children's needs. This could seriously undermine her case.
And does he get them extra days sometimes?
Not during that time, no.
Are you still married?
Yes.
Does your husband work?
Yes, he does.
What does he do?
He is an iron worker.
And you don't do like part-time jobs like Uber, DoorDash, something?
No, ma'am. With 6 classes, studying and taking the kids to their appointments and stuff like that, it's very hard to.
How close?
Find job.
How close are you to graduating?
I still have 3 years.
Boom. And there it is. The moment where it's clear this isn't really about custody or visitation, but financial struggle. She's in school full-time, no job, and now she's looking. at dad's income as a solution. Courts usually won't force the other parent to bankroll personal decisions, so this could backfire.
And you can't do part-time schooling?
Part-time schooling, no. Because every time I try to look for a job, everybody's like, well, you have to either be here early in the morning or you have to be here like really late. And my husband's commute, it would leave the children unattended.
Mr. Acevedo, about maybe taking them extra in that case?
We have not.
And we'll move on. Mr. Mangine, do you have any cross-exam?
Yes, I have a few, Your Honor. Miss Chesser, when we got this divorce done 3 years ago, you were employed at that time, were you not?
Correct.
And you say because you had to take the children to school or pick them up, that caused you to be fired.
Correct.
Okay. And did they monitor you when you were online doing this work?
Correct.
Okay. Now, since they fired you and you decided to go back to school, and you have already testified that there's no reasonable, in your opinion, no reasonable part-time job you could have to supplement your income.
Yes, sir.
Okay. And you also claim that Mr. Acevedo, you want sort of protection against him because of an incident that happened some years before that we got the divorce. And isn't it true that that incident arose out of the fact that you had voluntarily left the house, abandoned your husband and your children for a period of time, and then suddenly tried to come back and get into the house, which caused the problem? Isn't that?
That is incorrect.
And what is correct?
So I was not locked out of the house. I was actually forced out of the house. There was a police officer that came and did make a report that day.
Excuse me, I don't mean to interrupt you, but I'm not talking about what happened when the police officer came. I'm talking about what caused the incident to occur to begin with. Had you voluntarily?
So that incident that did occur, that had nothing to do with. We were already separated for 2 years. It might have been. And the incident happened because I was a minute late dropping off our daughter. It was her birthday. I had picked her up and I took her somewhere to go and eat, and I was a minute late, and he got upset about that.
Okay, when you left the house, how did you leave? You're trying to tell me that Mr. Acevedo forced you to leave the house?
Correct.
And why did he do that?
That was not the same incident that we're speaking of. So when I did,
no, I'm not speaking about the same incident. I'm saying when you left the house, whether it was 2 years before, 2 years after, why did you leave?
I didn't leave the house. Mr. Acevedo actually locked me out of the house.
And why
did not allow me to get anything, did not allow anything like that.
Okay. And why did that happen? Just because he wanted to do it?
Because he was upset.
And why was he upset?
I couldn't tell you why he was upset.
Were you having an adulterous relationship?
I was not.
You were not?
No, I was not.
I see.
The lawyer is hammering it home now. He's reminding the court that they had a full trial with a child's attorney who already ruled no child support was needed. This is a killer argument. Courts don't like to undo past decisions without good reason. If the judge sticks to precedent, this case might be dead on arrival.
And so now, Mr. Acevedo and you have been involved with a 50-50 sharing of child custody. And Mr. Acevedo makes sufficient money to support these children much better than you. And he is now got a budget that really doesn't leave him any spare money. And now you think it's fair that you should be able to come in here because you lost your job, whether it was because of the kids going to school, which we have to take your word for, or not. And now you think it's fair that he should somehow give you money to help you support these kids.
Well, it was actually requested before everything was filed. So, and it was just never talked about.
Are you staying with the divorce?
I'm sorry?
Are you saying it was filed with the divorce?
Yes, it was filed with the divorce.
Yes, and we argued that at court, and you'll recall that we had a bench trial on that issue. We even had a amicus attorney to represent your children, and at the hearing, the amicus attorney recommended to the judge that we have a 50-50 custody and no child support. Do you recall that?
I do recall some of that, but I do also recall that when we did ask for documentation, as far as when she asked for the documentation to see what everybody was, if it was fair as far as income for the kids, I do remember that there was no information provided on the other party's end.
That's not true. Otherwise, we wouldn't have been able to have the trial. Secondly, the amicus attorney did a full investigation, and I know because I paid her for her services. And she did a full investigation into everybody's income. She visited your home, Mr. Acevedo's home, on several occasions. And when she came to court and testified at the trial, she recommended no child support and 50-50 custody, which the court granted.